Megan Jabori, lead course instructor at JD Advising. This video is a sample of our brand new, highly reviewed lectures that have helped countless students pass the bar exam and realize their dream of becoming lawyers. For more information, please visit jdadvising.com. You can also sign up below to get our bar exam essay guide on the highly tested topics completely free. Enjoy the video and don't forget to like and subscribe for more valuable free content.
This question states, a man was arrested for burglary. When he was brought to the station, the police began to fingerprint him. The man unequivocally requested an attorney be present for the fingerprinting process. The police ignored his request and continued to fingerprint the man. Can the man successfully challenge the fingerprinting procedure and get the fingerprints excluded from evidence? First, we need to identify the subject. You might be tempted to call this an evidence question since they use the word evidence in the call of the question, but if we read carefully, he is challenging the fingerprinting procedure, which signals that this is a criminal procedure question. The legal issue being tested here is whether the man is entitled to have counsel present when his fingerprints are being taken. Let's turn to the applicable law and try to answer this question. Fingerprinting falls into pretrial identification procedures. There are two ways to challenge a pretrial identification procedure. First is the Sixth Amendment right to counsel, and second is a due process clause violation. Here the man requested to have his attorney present for the fingerprinting, so the focus is on the right to counsel. Remember that the Sixth Amendment right to counsel provides an accused with the right to have counsel present at all critical stages of the prosecution after the defendant has been formally charged. Critical stages include things like arraignments, probable cause hearings, sentencing, plea bargaining, police interrogations, and post-charge lineups. Procedures that are not deemed critical include blood sampling, fingerprinting, and samples of a person's handwriting, voice, or hair. With regard to identification procedures, the Sixth Amendment right to counsel exists for post-charge lineups and show-ups, but not for photo identifications or for fingerprinting. It is important that you memorize the nuances of what is and is not considered a critical stage of the prosecution, because the defendant only has a Sixth Amendment right to counsel at the critical stages. Even if you don't have them memorized, though, you can use common sense when thinking about when a defendant should have his attorney present. If the defendant is going to court for something like an arraignment or a probable cause hearing, he needs to have his attorney with him. However, if the defendant is simply being fingerprinted or having a hair sample taken, there isn't really much that an attorney could do during that procedure, so it doesn't really seem necessary to have an attorney present for those things. Now that we identified the applicable law, let's try to answer the question. Remember, the call of the question asks, can the man successfully challenge the fingerprinting procedure and get the fingerprints excluded from evidence? Since there is no Sixth Amendment right to have counsel present for the fingerprinting procedure, his argument that the fingerprinting procedure was unconstitutional will fail, and his challenge will not be successful. We therefore need to look at the no answer choices. Answer choice C states no because even though the police improperly withheld his right to counsel, the fingerprints will not be excluded. This is incorrect as there is no right to counsel here, so the police did not improperly withhold the man's right. Answer choice D states no because the man did not have a right to counsel for fingerprinting. This is exactly what we stated before. This is not considered a critical stage of the prosecution, so there is no Sixth Amendment right to counsel here. Answer choice A is incorrect. It states yes because he was not given his right to counsel, and as we previously stated, there is no right to counsel under these facts. And finally, answer choice B states yes because the man unequivocally requested an attorney. This language suggests that the man is attempting to invoke his right to an attorney. Invocation of the right to counsel happens under the Fifth Amendment right to counsel. However, the Fifth Amendment right to counsel does not apply to identification procedures. It only applies when the person is subject to custodial interrogation. So we only need to focus on the Sixth Amendment right to counsel to answer this question and not the Fifth Amendment right to counsel. So even though he asked for an attorney, he has no Sixth Amendment right to an attorney under these facts, and this answer choice is incorrect.